What is the difference between a DUI conviction and a reckless driving conviction in Georgia? Many of my clients who are charged with a DUI end up hoping for a reckless driving alternative. And the way that works is, if you're charged with a DUI, but the evidence is for some reason incompetent or less than ideal, a prosecutor may be willing to dismiss the DUI in exchange for the reckless driving. Now, although it's possible to get a reckless driving without a lawyer, in most instances, prosecutors are not interested in offering a reckless driving unless it's been shown to them that there are some deficiencies in their case. So a deficiency might be a problematic breath test, or a mistake the officer, or several mistakes the officer made. Sometimes if the prosecutor is worried about witness credibility, that might be compelling to them to reduce the case. Sometimes if they're worried about losing additional evidence because of procedural issues in the investigation of the case, they might consider reducing the case. Other times, after having a hearing, they may see that they are more vulnerable than they originally thought to losing the DUI at trial, and so that will influence them to consider a reckless driving. There are a lot of different factors that go into it, but typically speaking, prosecutors are only interested in dismissing the DUI in exchange for a reckless driving when they, in some way, shape, or form, think that the evidence that they have is less than perfect, or for whatever reasons, prosecuting the case might be challenging. It is rare to find a prosecutor who is interested in reducing a DUI from a reckless reducing a DUI to a reckless driving because the person who is charged is a good person or is otherwise deserving. So many times I have people call and they say, well, I've never gotten in trouble before. I'm a straight A student. I volunteer all the time. And while those are all good things, and those are things that you should absolutely tell your attorney about because they are helpful when negotiating, those are not going to be the factors that carry the day when it comes to getting your DUI dismissed. The mindset of most prosecutors is that their evidence, or the quality of evidence that they have, must be in jeopardy in order to consider dismissing the DUI. You want to make sure that you meet with a lawyer or hire a public defender to strategize about where those vulnerabilities may be. Because although you as the driver may perceive some vulnerabilities, for instance, people always ask me about the ticket. Well, the officer misspelled my name or got something wrong on the citation or the report. Well, that may be an interesting fact that can go into the analysis and be relevant at trial. Those small details may not, often in Georgia at least, convince the prosecutor that they need to reduce a DUI to reckless driving.